we've now going to take a little bit of a darker route. And Cilna, I believe this is because of you. And but it's a nice dark route. So we're going to take it and we're going to see where we end up with this. So there's a tenant. Yeah. So there's a tenant in a property, and there's a managing mandate from the landlord. The landlord now passes away, and the lease agreement with this tenant is coming to an end. Can the agent market the property and place a new tenant in that property? Cilna, I'm saying dark because this is around death, and yeah, can we do this?
I think I first need to explain why you say this is because of me. So actually, before we start, I'm alive and well, thank you. No, I told Chris before we started, it's actually such a sad situation. I have, that's not sad that I have WhatsApp groups for the agents, but it's a sad situation because 2 days ago, I had 8 questions across the WhatsApp groups I have for the national agents for the different agencies around people passing away, landlord passing away, tenant passing away, agent passing away. And it was such a grim thing. And I said to Chris, let's now just carry on with these questions, because the fact that I get 8 relatively similar questions on a day probably means there's quite a few of our viewers with the same question. So that's where it's coming from. So let's address that. I think one of the things that's happening, and unfortunately it is the situation right now that we are seeing more people passing away unexpectedly, and it raises a lot of questions, be it the landlord, the tenant, the agent. And it's a sad situation, it's a sad thing to talk about, but unfortunately, it's better to address it now in advance instead of being in a situation of trauma and then trying to find your way around it. So in a situation where you, as an agent, have a managing mandate on a property, that mandate agreement will be linked to the particular lease agreement and the particular tenant. To have an open-ended management agreement, management mandate is a very risky situation, because on the one hand, you place a tenant, and without getting a new mandate agreement from the landlord every time a lease agreement comes to an end, could very well mean that the landlord sort of expects you to always have a tenant in there. And what happens if you can't place a tenant? What happens if your tenant, the last tenant, didn't give you proper notice? You can't place a new tenant in time, then the landlord's going to look to you as the agent. So my advice to agents is always do a new mandate agreement per new lease agreement. So your mandate sort of runs with your lease agreement. Remember, they can't have a baby. It's not a tripartite type agreement, not your lease agreement and not your mandate agreement. Mandate agreement is between the agent and the landlord, and your lease agreement between the landlord, potentially assisted by the estate agent, and then the tenant. They can't have a baby. It must be separate agreements. So if your mandate agreement is then attached to the lease agreement, the landlord passes away and there isn't an executor appointed yet, or there isn't somebody with power of attorney safe prior to the person's passing away, it would be extremely risky for you as the agent to proceed to market that property and place a new tenant at the end of that initial lease agreement, because you are not mandated to do that. And the reason why this makes me nervous is if you simply carry on and you place a new tenant, remember, the principles of huur gaat verkoop will apply. So say, for instance, the executor is then appointed and the executor has to sell the property to finalize the estate. If there's a tenant in place, that lease agreement will pass through the transfer, and the the executor will have a bit of a difficult time. And if you as the agent did something without being mandated to do that, the first thing that's going to happen is the executor is going to claim the commission back, because you can't claim commission if you didn't have an agreement with the landlord. We just can't just randomly place tenants in random people's places. So I would be very reluctant to do that. However, I've had quite a few, part of those questions I had on Monday was if there's a couple that was married in community of property or out of community of property, does not matter, but they both worked with the estate agent, the surviving spouse will be appointed as the executor. If they then give you written mandate, it's a bit of a gray area, but I must say that's the only case where I would probably be a bit more comfortable. But the correct answer in law is wait for the executor to be appointed, have a conversation with the executor. If the landlord passes away, it does not end the lease agreement. And so the tenant that's in occupation, that lease agreement remains of full force and effect. And the same goes for a situation where a tenant passes away. Death of neither the landlord nor the tenant terminates a lease agreement.
Thank you, Cilna. I'm a tenant in a block of flats owned by one individual. Recently, my landlord has been making my stay extremely uncomfortable. He has allowed individuals to occupy vacant units on my floor rent-free. These individuals are extremely loud and at times aggressive. I believe my landlord is trying to force me out of the property without following due process. I have never defaulted on my rent, and I have never breached any of the terms in my lease agreement. What are my rights in this regard? Bruno, can we advise here?
So it's an interesting question, because I mean, I suppose it comes down to the facts, which is always difficult, because I mean, we, especially as lawyers, we always work on either one side or the other side, depending on the version and depending on who your client is. So, I mean, from the landlord's perspective, the fact is the landlord is entitled to do with the property as they please. If they want to rent the property out to someone, they can. If they want to put people on the property that don't necessarily pay the same amount, or aren't paying at all, it is technically their prerogative, because as owners, they have that right to be able to do with it as they please. But this is always going to be subject to certain limitations. And I mean, the biggest story in South Africa obviously is limitations in terms of the constitution, but you're also looking at just individuals' rights. So in this relationship, you wouldn't be able to do whatever you want that prejudices somebody else. So that's always the right of an owner versus an occupant, and who actually has right to reside, etc., and the balancing of these. So in a case like this, it depends from what angle you're looking at. So if we put on the landowner hat and assume that he is innocent and not doing anything wrong, sorry, it's, he's entitled. And if he can justify it, he can justify it. Interestingly enough, from that perspective, just a little bit of a warning. I've had encounters with the Rental Housing Tribunal when it comes to the amount of rent being charged and complaints being laid by tenants in inner city buildings, where the amount of rent can be assessed by the Rental Housing Tribunal, and they can give awards that adjust this rent. So in a situation where you're renting out the property for far less to somebody else, and this goes to the Rental Housing Tribunal, just be warned that might be some factor that they consider as to whether what you're charging is fair or not fair. But I mean, aside from that, because that's like a digression, now if you look at it from the tenant's perspective, a lot of situations like this very often arise where landlords, for instance, especially in communes, they do it intentionally, where they stick people in adjacent rooms, to make life uncomfortable for tenants that they do want to rid themselves of. If there's sufficient evidence to show that this is the intention of the tenant, of the landlord, and the tenant is suffering prejudice because of this, arguably, I would say yes. You know what? There is a case to actually get interdicts or go to the rental housing tribunals, lay the necessary complaints. Absolutely, it is a difficult one to prove because if everyone's very subtle about how they causing this inconvenience, it might be difficult to say, well, they're loud. It's like people are loud. Like you can't always blame the landlord if, you know, if somebody's loud occasionally or doing so. So it is a bit difficult, but if it's apparent and if one can really tell that this is a move and like you get communication that this is in fact the case and that's why they were put there, go to the rental housing tribunal if budget is an issue, and they should be able to assist you with this. If you'd prefer, an attorney would actually be able to also assist through interdicts using the court system. That's obviously a bit more expensive, but yeah, effective.